I call this meeting to order. Welcome to meeting number 94 of the House of Commons Standing Committee on Public Safety and National Security. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I would like to make a few comments for the benefits of witnesses and members. Please wait until I recognize you by name before speaking. To prevent disruptive audio feedback incidents during our meeting, we kindly ask that all participants keep their earpieces away from any microphone. Audio feedback incidents can seriously injure interpreters and disrupt our proceedings. Right here?
Yeah.
Now?
Unless you...
March 27th, 2023, the committee resumes its study of Bill C-26, an act respecting cybersecurity, amending the Telecommunications Act and making consequential amendments to other acts. We have today two panels of witnesses. I would like now to welcome our witnesses for the first panel. In person, Office of the Privacy Commissioner of Canada, Mr. Philippe Dufresne, Privacy Commissioner of Canada. By video conference, Office of the Superintendent of Financial Institutions, Mr. Togol Yakin, Assistant Superintendent Regulatory Response Sector, Citizen Lab, Ms. Kate Robertson, Senior Research Associate, Monk School of Global Affairs and Public Policy, University of Toronto. Up to 5 minutes will be given for opening remarks, after which we will proceed with rounds of questions. Welcome to all. I now invite Mr. Dufresne to make an opening statement, please.
Merci, Monsieur le Président, Mesdames.
Thank you, Mr. Chair, ladies and gentlemen, members of the committee. I'm pleased to be here to assist the committee in its study of Bill C-26, an act respecting cybersecurity, amending the Telecommunications Act and making consequential amendments to other acts. In Canada and elsewhere, cybersecurity is an important domain. Digital services that are delivered through cyber systems and telecommunication networks are central to the ways we live, work, and interact. And they have an impact on great data and personal information. That is why it's important for us to protect Canada's cyber infrastructure from potential threats.
We must ensure that efforts to secure these systems and networks also protect and respect Canadians' fundamental right to privacy. This is not a zero-sum game, and privacy and the public interest are not only compatible, they build on and strengthen one another. I strongly support the objectives of Bill C-26 and believe that as a society it's imperative that we have the necessary tools and the ability to address this important public interest goal. In my testimony today, I will share ways that the bill could be strengthened in order to further protect the fundamental right to privacy and address potential privacy implications while achieving the bill's important objectives. Under Bill C-26, specified persons or entities would be able to collect and analyze a wide range of information, including sensitive personal information that is held by banks, telecommunications operators, and energy services providers. The bill would also allow for the sharing of that information with organizations such as intelligence agencies, provincial and foreign governments, as well as organizations established by foreign states. Selon le projet de loi tel qu'il est rédigé, c'est
As drafted, the powers are broad in order to ensure that personal information is protected and that privacy is treated as a fundamental right. I would recommend that the committee consider making the thresholds for exercising these powers more stringent and placing stricter limits on the use of those powers. One way of doing so would be to require that any collection, use, or disclosure of personal information be both necessary and proportionate. This is a core principle for the handling of personal information that is recognized internationally.
To conduct privacy impact assessments, or PIAs, and to consult my office on new programs or initiatives created under the authorities in Bill C-26 would also strengthen privacy protections while supporting the public interest and generating trust. PIAs, which are currently a policy requirement under the Treasury Board Secretariat's directive on PIAs, but not a legally binding requirement under privacy legislation, are an important tool for identifying, analyzing, and addressing or mitigating privacy issues before initiatives are put in place. And they can help to reduce inadvertent harms to privacy as initiatives roll out. This is why I've recommended that the preparation of PIAs should be made a legal obligation for the government under the Privacy Act. Bill C-26 would also allow the Minister of Innovation, Science and Industry Canada to prohibit public disclosures of certain orders and directions made under the proposed act. It's important that any such confidentiality provisions, which have the effect of reducing public scrutiny regarding the bill's implementation, including collection, use, and disclosure of personal information, be accompanied by appropriate transparency measures. This could include requiring the government to report to Parliament and or to my office regularly on the number, nature, and purpose of such orders and directions, especially when they involve sensitive personal information. This would reassure Canadians that their privacy is protected at all times. Je recommanderais aussi que le projet de loi soit amendé afin d'inclure des mesures de responsabilité.
I will also recommend that the bill be amended to include stronger accountability measures to ensure the protection of personal information that is shared outside of Canada. This could include, for example, additional oversight mechanisms and established criteria that must be included in information sharing agreements with foreign jurisdictions, such as restrictions on any onward transfers of the personal information, establishing safeguards that must be applied, and consequences for non-compliance. Finally, should Bill C-26 be adopted, it will be important that my office has the necessary flexibility to coordinate as appropriate with other regulatory and oversight bodies that are involved in responses to cybersecurity threats in cases that may involve a breach of personal information. I'll be happy to take your questions now.
Thank you, Mr. Dufresne. Mr. Yakin, please, if you could go next. And if I'm not pronouncing your name right, please correct me.
No, that's perfect, Mr. Chair. Thank you so much. Bonjour, Monsieur le Président, Madame.
Good afternoon, Mr. Chair, ladies and gentlemen, members of the committee. The OSFI mandate contributes to ensuring that the public has trust in the Canadian system. Besides the regulations of some 400 federal institutions, in that capacity, we ensure that financial institutions preserve great financial health, continuously assess any risks and trends in the sector, and also protect against threats to integrity and security, including cyber threats. There is no doubt that financial institutions are targeted by cyber attacks. It's something that has been well noted in our assessment published online. And cyber risks are seen as one of the major risks concerning the financial stability of Canada.
Won't surprise you that we have been for some time active as a regulator in expecting our financial institutions to adopt appropriate risk management practices in the face of cyber risks. More specifically, we've taken pains to clarify in our guidelines our expectations for how financial institutions should manage technology and cyber risks to prevent things like outages and data breaches and improve overall technology and cyber resilience. This includes also an expectation that financial institutions respond to tech and cybersecurity incidents quickly and effectively, and importantly, notify us whenever an incident happens. And that reporting really helps us identify areas where individual institutions or the industry more broadly need to take steps to prevent issues from arising. We also provide tools to financial institutions. So a good example of this would be our cybersecurity self-assessment, which helps them evaluate their current level of cyber preparedness and develop effective cybersecurity practices. Not to mention as well our ICERT framework, which stands for Intelligence-Led Cyber Resilience Testing, which provides instructions to financial institutions on how to implement a sophisticated approach to what is known as red teaming. These efforts and others are critical, in my opinion, as there's little question that cyber attacks will continue to increase in frequency and sophistication. Moreover, this is a risk environment that in our experience changes rapidly and for which failure to protect against can have serious consequences. Successful cyber attack could impact the confidentiality, integrity, and availability of data and systems, which in turn could result in loss of public trust, reputational damage, and financial loss. C'est pourquoi
That is why the OSFI is focusing a lot on promoting the proper management on cyber risks and other risks, and all federally regulated financial institutions under our responsibility. We are responsible for regulating sectors designated as important. The OSFI and myself are at the disposal of the committee to provide our support as you study Bill C-26. So we are ready to provide our assistance to improve the resiliency of Canada's financial system. Thank you, Mr. Chair. I will be happy to answer questions from the committee.
I now invite Ms. Robertson to deliver her opening remarks, please. You're on mute. Ms. Robertson, can you re-plug in your device? Try that.
Testing.
You're good to go. Thank you.
Wonderful. Thank you. Thank you, Mr. Chair and members of the committee. As you know, I attended before this committee last week in relation to this bill. I'm a senior researcher at the Citizen Lab, which is based at the Munk School of Global Affairs and Public Policy at U of T. I've submitted a written brief to this committee along with a colleague, Lena Lee of McGill Law, which builds upon the research and analysis of my former colleague at the Citizen Lab, Dr. Christopher Parsons. Today, I will readopt my comments from last week and supplement them as follows. First, several concerns have been raised throughout these hearings focusing on malicious targeting, such as ransomware, of aspects of the economy that are outside of federal responsibility, such as in hospitals. The need for protection in other areas is important, but this committee can also be mindful of the proper scope of its responsibility in its work on Bill C-26. I also appreciate other committee witnesses raising threats facing Canadian society today. However, it is never a good idea to legislate out of fear. This is an important issue that requires careful due diligence and reflection as to what goes into any amendments. I'd suggest the committee carefully look at what you are doing. Making the right decision now could improve the security, safety, privacy, and charter rights of all people in Canada for decades going forward. So it's incredibly important that lawmakers are thoughtful, nuanced, and reflective of the kinds of amendments they pose to the legislation. Secondly, our brief sets out recommendation 12, including 12A through C, pertaining to judicial review proceedings under Bill C-26, and includes a recommended appointment of special advocates in judicial review proceedings and the need to align Bill C-26 with analogous provisions under the Canada Evidence Act applicable to secret evidence. Not only are these amendments important, they are also fair, simple, and common sense enhancements. Lastly, I also wish to address our recommendation that government entities that are empowered with new information collection and sharing powers be required to limit the use of that information to cybersecurity and information assurance. The collection or use of information by national security intelligence agencies, such as the CSE, about Canadians or persons in Canada is a core matter of public and constitutional concern. The concern that the CSE may repurpose information that it receives through Bill C-26 into its other intelligence activities is not a speculative one. Recent reporting from the National Security and Intelligence Review Agency, or NSIRA, documents that at this time the CSE does not consider itself prohibited under its home statute from repurposing information about Canadians across its mandates. However, only a few years ago, an important equilibrium in Bill C-59 was struck by Parliament concerning the need for important limits, given the prohibition against intelligence agencies directing their activities towards people in Canada. And Bill C-26 could destabilize this important equilibrium. It currently contemplates broad and even secretive government collection and sharing powers about information concerning people in Canada. While the Department of Justice's charter statement on this bill has referred to the government's potential use of only technical information and not sensitive personal information, there are no caveats or safeguards to stipulate this in the legislation. Clarity is needed. Telecommunication providers, for example, are quite literally conveyors of the most private information known to our legal system. I agree with witnesses from CIRA and Open Media that this is a core matter of public trust. The public should not have to be asking itself whether the government's cybersecurity bill is actually a spy bill under a different name. As noted by Mr. Hatfield last week, and CIRA has reported a chronic problem in reviewing the lawfulness of the CSC's activities since its inception, lawmakers here should be very cautious when considering whether extending additional new powers is appropriate or necessary under Bill C-26, and what corresponding judicial oversight mechanisms are necessary and fit for purpose to protect the privacy of all people in Canada. Thank you, and I'm happy to answer any questions that you may have.
Thank you, Ms. Robertson. We're going to open the floor now and move right into questions, and we'll be starting with Mr. Shipley, please, for 6 minutes.
Thank you, Chair, and thank you to the witnesses for being here today. C-26 is a very important issue. I'm going to ask just for a little bit of time on this, and I have no intention of infringing on anybody else's time today, Chair, but I would like to just move a motion quickly that's on notice and hopefully get back to C-26 quickly. It's a short motion. It states that the committee acknowledged that auto theft is a pressing issue facing Canadians, and pursuant to the motion agreed upon regarding auto thefts on October 23rd, 2023, the committee commenced this study on Monday, February 26th, and dedicate the following 6 Monday meetings to this study, while reserving the committee's Thursday meetings for the study of Bill C-26. Additionally, pursuant to the motion agreed upon regarding the rights of victims of crime, reclassification and transfer of federal offenders on October 23rd, 2023, that the committee extend its meeting on Thursday, February 15th for an additional hour, and the minister be invited to appear for the full 3 hours in order to discuss all matters related to his mandate. Chair, I feel this is a reasonable approach and motion to prioritize a serious issue. I think all of us around this table agree auto theft is a serious issue. The reason we've added in trying to get a little bit of time extra with the minister is it's not come to our attention. We've known for a while that we have not had a minister report to this committee since May 30th, 2023, and the last time a minister came for estimates was May 19th, 2022. We all passed a motion on October 23rd, 2023, that furthermore, that the committee invite immediately the Minister of Public Safety and department officials to appear for 2 hours to discuss his mandate. So I was just hoping to consolidate some of those meetings together and make our time work a little better. And perhaps the minister, if he can fit it in a schedule, could find the time to talk to us about many pressing issues that are going on here right now. And with that, I will concede the floor, Chair.
Thank you. Anybody? No more comments? We'll continue on. C-26. Well, Ms. Michaud, please. Oh, he actually never make the motion.
Merci, Monsieur le Président. Je peux parler.
Thank you, Mr. Chair. Can I speak to the motion? Thank you. It's been a while that we've not have to respond or speak to a motion. It is true that the minister has not yet come to testify on his mandate in general, whereas that should have happened at the very beginning of the year, or even in the middle of 2023, when he was appointed. He has still not appeared before the committee. So I agree with that part of the motion. Now, I'm not against that motion, but I do not have the intention to delay Bill C-26 either. So I think it's reasonable for us to do the same at the same time. So I am in agreement with the motion, so I don't know if we have to vote on it today, but I will be voting for the motion. Thank you.
Julian.
Merci beaucoup, Monsieur le Président.
Thank you, Chair. I would like to welcome first years, or rather fifth year secondary students in St. Hyacinthe who are participating in our meeting today. I would like to raise a number of issues concerning the motion. I always prefer that we have a discussion with the executive committee because there are various functions. First of all, I totally agree, but with the minister appearing, but Thursday it may be difficult, I think. Now, the idea that we proceed as quickly as possible with Ms. Michaud's study that we all supported is also very important. The idea that we are still continuing with delays, it's been a month now that we've had some disruptions in our discussions and witnesses on Bill C-26. So I think it's possible for us to come up with all the improvements we need to do on Bill 26, which is very important. I'll be voting against that motion, but I'll be raising the matter with the executive committee, and I do hope that we can have a meeting as quickly as possible. I think it's important that we agree on a timetable. We invite the minister very fast. I agree that the minister has not appeared here often, and that has to change, and we need to discuss this topic on auto theft as quickly as possible following the discussions on Bill 26.
Please.
Thank you, Chair. I would just like to point out that if it weren't for conservative filibusters, we would have been finished C-26 and we would be on auto theft right now. And so if this was such a serious issue, then they wouldn't have brought up Emergency Act motions. I think at least 6 of the same thing, just changing how many meeting dates. They would have gotten to the point of, I believe it was just the last meeting, which was the first time a conservative member actually asked a question to witnesses on C-26. So if it was such a concern, we would have actually already been studying auto theft, which was Ms. Michaud's motion to begin with, which we all agreed with. So I think it's crucially important that we finish C-26, we move forward with auto theft, and we can do that while C-26, we still have to submit amendments and things like that and then get to clause by clause, but we can do auto theft in the meantime. I will just confirm that the minister is scheduled on C-26, both Minister LeBlanc and Champagne for February 15th, and he's also confirmed for his appearance, Minister LeBlanc, for March. I think we're only sitting 1 week in March, so he's there on his mandate, and it's been confirmed to the clerk. So those are both scheduled, and I would like to point out the minister was available sooner, but we were in a different study, and it was decided to invite other witnesses before. I recognize the frustration in terms of scheduling the minister. I have been taking that back, but if it weren't for all of the continuous filibusters, we would have been in a very different place from committee. So I think we need to finish C-26. We only have, I think, 2 more meetings left after this. We have the ministers and then 1 more, I believe, and then we can move forward. But if we continue to get filibustering motions from the Conservatives and they're not serious about talking about C-26, then, yeah, we're not going to be able to get to auto theft, and it's a shame that they've done that since it's really important. So I would very much hope that we can finish the study and move to auto theft, which was always the plan, and which, again, we would have been there if it wasn't for Conservatives wasting committee time and taxpayer time talking about motions that they actually never even wanted to vote on.
Thank you. And yes, the minister is scheduled for Thursday, March 21st, and we all know our schedule in March is broken, so it's we'll expect him here on the 21st. So there's a motion on the floor. Do we want to show of hands, a vote? Recorded vote.
Ms. O'Connell.
No.
Mr. Biddle. No. Mr. Gay.
No.
Mr. McKinnon.
No.
Mr. Shifke.
No.
Mr. Shipley.
Yes.
Mr. Lloyd.
Yes.
Mr. Mutz.
Yes.
Mr. Kirk.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Contre, opposé.
5 yeas, 6 nays.
Okay, we're going to move on. Oh, sorry. Yeah, Mr. Gahir, you're up next for questions.
Thank you, Chair, and thank you to the witnesses for making time for this committee. My question is for the Privacy Commissioner, Mr. Dufresne. Am I pronouncing that correctly? I am. Okay, thank you. So I'm wondering, when is it normal for the Privacy Commissioner to weigh in on the legislation? Is it during when the legislation is in committee, or is it when it's going through the regulations process?
Well, we do so at any appropriate time. We would hope ideally to be consulted prior to the bill being tabled, but it's the regular way is for my office and myself to be called to committee and give recommendations on the bill. We can also do the same for regulations and consultations with the government.
Your office will be involved in consultation on the regulations when that process goes on?
I hope so. We're certainly prepared for that, and we would call on the government to involve us in that.
We know that during the course of the committee study on C26 so far, we've heard a lot of stakeholder reaction around privacy rights and information sharing, and you touched on this in your opening testimony a little bit as well. Do you have any suggestions of how these concerns can be mitigated through regulations, especially in regards to when the data is crossing national boundaries?
Well, certainly in terms of crossing national boundaries and sharing it with other institutions, my recommendation is to make sure that we have specific requirements for these information sharing agreements, so that the purpose, that the retention, that the safeguards for that information by our international partners, that all of these are set out, that they're strict, that there's dispute resolution mechanism, just so that we bring in more rigor and guardrails to those exchanges of information. And also that the concept of necessity and proportionality be included as well when determining to share the information in the first place.
What role would your office currently play, or how would your role change, or your office's role change, based on how the legislation is worded so far?
Well, the legislation currently doesn't provide a role for my office, so the role would be under the Privacy Act. So we have jurisdiction over the government's handling of information. We have jurisdiction over private sector's handling of the information. One of our recommendations is to have a more transparency mechanism so that we can know what is happening, so that we can know what type of information is being collected, disclosed, used, so that we can exercise our powers in that regard. So those reports, there's provision in the bill for an annual report by the minister overall. We're recommending that this be more specific, that there be more details about what is happening. We would also have a potential role in working with the regulators in cases of cyber breaches and incidents, and it would be important, one of my recommendations, that we be given the ability to collaborate with those regulators and, as needed, exchange information and work collaboratively when cyber incidents involve personal information, and we know that that's a big area of concern for Canadians.
So I think in your opening testimony you touched on this. I just wanted to go over it maybe one more time. I think you would wish more came under your purview based on what this legislation is bringing in. Is there anything else that you'd like to have oversight on? Or
I'm not suggesting that we would have oversight under this legislation. I'm suggesting that we be given the necessary information so that we can fulfill our mandate under privacy legislation and under public sector and private sector privacy information. One of the recommendations that I've made is for privacy impact assessments to be mandatory and that I be consulted on those so that we can provide insight and advice to departments, because when that happens at the front end, these issues can be corrected and addressed before they become issues that can impact Canadians' trust. So it's not so much the fact that my office would be the regulator. In many instances, we're not. I'll give the example of former Bill C-11, which falls under the CRTC. So the CRTC has jurisdiction, but we can provide input, and the bill recognizes privacy as a consideration.
Great to have you at committee.
Thank you.
Ms. Michaud, please, for 6 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Thank you, witnesses, for being here. It's appreciated. Mr. Dufresne, during your opening remarks, you expressed your fears when it comes to privacy protection, and that's a fear that has been raised by many of the witnesses that come here. You have made a recommendation that is different from what we've heard. That is that we consult you. The mandate of the commissioner, of the commissioner's office, ensures respect of the Privacy Act, which has to do with the processing of personal information used by federal institutions and organizations. Therefore, under the framework of Bill C-26, if it becomes law, you are proposing that public safety, the Public Safety Department, or the minister in this case consult you. Is that the case with other bills, that a department or a minister go through you when it comes to privacy protection? If that's the case, could you give us examples that could give us an idea on how that would work in this case? Indeed, what we are looking for is that when an activity has an impact on privacy, of course, there's a matter of safety that doesn't fall under our mandate. That doesn't have to do with privacy. We are not trying to broaden our mandate. But there are lots of situations. For example, the Treasury Board policy provides that departments have to consult us when activities or projects may have an impact on the private lives of Canadians. That is not always done. It's a policy. It's not a legal obligation. We are recommending that it be included in the Privacy Act. There are also situations where we worked with NCIRA, the security agency, and when we looked at the practices of departments on how information is transferred, there's the issue of safety, there's the issue of privacy. I recently set up, together with my colleagues from the Competition Bureau and CSTC, a digital regulatory forum, because we realized that there are many sectors where there's overlapping. There's competition, there's privacy, there's broadcasting, and there's a lot of overlapping. So we want to coordinate our activities to make sure that there's no contradiction. So what we are recommending here is that since it's policy for privacy to be affected, we want to make sure that my office is informed. It's going to be beneficial, not only to do so, but it also reassures Canadians. Absolutely. Part of your explanations are very important. We need to reassure people, but you are also saying if it's in the law, the department or minister is not necessarily obligated to consult you. It's a recommendation. Did I understand you well? Or if we add it in the law or make amendments, will it oblige the minister or department to consult you? If it's in the law, it becomes a legal obligation, and in that case, the department will do so. You also talked about additional control mechanisms. This is a matter that we've heard a lot. Powers should be given through order and so on. Now, we're trying to have an idea what all that could represent. There are fears expressed about that. How can we better control all that, in your opinion? It's good to say the minister has the right to do X or Y, but the House and parliamentarians may not necessarily have control over that. It's the government. So the idea is how to better protect privacy. What can we do? How can we better control that? We can add a proportionality and necessity clause, and it's the proportionality aspect that is lacking. The necessity aspect is now in the law. If the minister is of the opinion that it's necessary, it's there. There's also the idea of relevance, but the idea of proportionality is important. When it comes to necessity, we can say, yes, we need this to attain our objective. But when we talk about proportionality, we want to check whether it was really the least intrusive method. So we have to also establish a balance with the Charter. So that is important. And we could add the idea of necessity and proportionality, which is a core principle when we talk about privacy, particularly on the international scene, whether it be Australia, New Zealand, or Great Britain, they all have some specific issues about that. They consider privacy, they consider the other options. It's not that we're trying to prevent the minister from doing his job. Absolutely not. I strongly support his objectives, but we want to add this obligation to be able to think about this more, especially when privacy is concerned. Thank you. Are there other elements that you'd like to share with us? Still in the context of privacy, but things that could reassure people or organizations or businesses that need to comply with this law, with this bill, if it becomes law. Some have talked of an additional workload, lots of bureaucracy, but there's also the idea of exchange of information. There are fears there. So what are the additional elements you would like to add? When I talked in my speech, I talked about all that. We want to reassure Canadians as well as SMEs. We are saying the institutions are here to help you. We are not delegating everything to individuals or to SMEs 100%. Be it an assessment of privacy factors, it's obligatory if there's a consultation in my office, but people need to understand that there's a control function. The commissioner should be aware and could make recommendations and could initiate lawsuits. When we talk about transparency now.
Mr. Julian, please.
Merci beaucoup, Monsieur le Président.
Thank you, Chair. Thank you, Mr. Dufresne, for your service to the House of Commons. Your parliamentary service and now in your role as Privacy Commissioner. I have two questions for you to start, and I want to thank all the witnesses for all the information that they've just shared with us. You mentioned the importance of reviewing factors that have to do with privacy. You think it's important that in this bill C-26, there should be an obligation about that. Now, have you been faced with government or non-governmental organizations that consulted you? Because this has been on, this bill was tabled since June 2022, so there's an impact. So has any organization not contacted you for this assessment? What will be the impact on Bill C-26? For now, there's no obligation in Bill 26 for us to carry out assessments. There's an obligation by virtue of the Treasury Bill, Treasury Board policy. We have an office with the government, a consultancy service, and we are there to advise the government and departments. What we've seen, well, I appeared before ethics to talk about that, the ethics committee. Sometimes these assessments are done later on after the tool has been used, and sometimes Canadians learn that a tool is being used or that there's a program, and this undermines trust. So now we are asking that this assessment should be done before and should be known. It should be known that my office is consulted. When it becomes public, people start asking questions. Were there consultations? And so on. They need to know that that was done, and that's what I would like to see in Bill 226, given the potential impact. Thank you very much. Last question for you. what are the best practices being used by other countries when it comes to privacy to prevent information being shared outside the country. Information could be shared outside the country as long as it respects legitimate agreements. For example, the European model will require that laws and mechanisms be equivalent to what exists in Europe. In Canada, in the law, it is provided that it should be equivalent through contracts to what we have in Canada. So in my recommendation, we are saying if information has to be shared with organizations from other jurisdictions, we must have an obligation in the law that specifies the retention practices, the necessity, proportionality, security measures, because we don't want all that information to be targeted by cyber attacks. Thank you very much.
Yelkin, you raised with OSFI, I think, some important issues. I had two questions for you. First off, have you been consulted at all on C26? Was the banking sector consulted before the legislation was tabled or afterwards? And secondly, how many incidents have we had within the financial institutions covered by OSFI's mandate where there has been a cyber attack? How many cyber attacks in 2023? And is that number increasing, decreasing, or staying stable?
Mr. Chair, we were engaged by public safety on the bill itself. In terms of consultations with other stakeholders, I defer to them to be able to respond to those questions. And should the bill come to pass as well, too, obviously we would look forward to engaging public safety in the development of the regulations and expect as part of that process that the banking sector would be engaged or have an opportunity to engage. In terms of the questions of the frequency and severity, perhaps, of cyber incidents, I can share a little bit of information on that. We have seen an increase. So in 2022, I believe, when it comes to sort of cybersecurity incidents, because we do have a reporting protocol that financial institutions are expected to comply with, basically alerting us within 24 hours if a technology or a cyber incident occurs. So in 2022, I believe we had 10 what we call priority 1 incidents, but we saw a significant increase in this in 2023. So I think the number almost trebled to about 28 in 2023. So basically, moving from 2022 to 2023, we had a number of more impactful incidents that represents a significant growth from our perspective as prudential regulator.
Can you share with us, I'm going to move on to Ms. Robertson, but can you share with us how priority 1 is defined for a cyber attack or a cyber incident? If you could let the committee know, that would be very helpful, or one of my colleagues may follow up on this. Ms. Robertson, you've identified in your paper the importance of having a special advocate. Could you speak a little bit more to the importance of that in the legislation?
Yes, of course. Special advocates are intended to enhance the fairness of a closed hearing process concerning secret evidence without compromising Canada's ability to safeguard security information. They protect both fairness for the party who is excluded from the closed hearing, but also the public's right to free expression by ensuring that any secrecy in the court proceedings is necessarily justified. And so you can have special advocates both challenging either the amount of secrecy that the government is seeking in respect of the evidence, or test with due diligence and adversarial submissions the sufficiency, the weight, the appropriateness of the evidence that the government seeks to rely on. There's a very long history in the courts of using special advocates to protect the openness of courts as well as the fairness of those proceedings.
Thank you, Ms. Robertson.
Yes.
Thank you, and thank you, Mr. Julian. Now we're moving on to the second round, and Mr. Lloyd, please. 5 minutes.
Thank you, Mr. Chair. Go straight into the questions, starting with Ms. Robertson. When we're talking about Canadians' private information, we're talking about information sharing, it can all seem a bit abstract. And I was wondering if you can provide some examples of what you could imagine, like what kind of information are we talking about that we're concerned about being inappropriately shared between agencies?
The breadth of the collection and sharing powers means that the list of hypotheticals with respect to both critical infrastructure providers as well as telecommunication providers could be quite long. To provide one hypothetical example, there is a potential that the minister could compel telecommunication providers to furnish subscriber information with respect to individuals using telecommunications networks anonymously in circumstances that have been the subject of Supreme Court of Canada's guidance around the importance of protecting the privacy interests of that type of information. And that information, there would be, on the terms of this legislation, no apparent restriction in preventing that information from being shared to other government agencies identified in the bill, and potentially repurposing that information for other aspects of their mandate, such as providing assistance with federal law enforcement.
I was legislative review. The minister doesn't even have to make these orders known. They can be confidential. Usually, they have to be posted in the Canada Gazette, where everyone can access it and see it. But the minister can make orders that that information be withheld from the Canada Gazette. Are you saying there's a situation where Canadian citizens could have their private information ordered, a telecommunication order to provide their private information, and the subject of that might not even know that that's happening and have no recourse to learn that that's happening to them?
Yes, that's a function of the absence of both publicity requirements in respect of the orders themselves, as well as the absence of any notice obligation set out under Bill C-26. And we've recommended in our brief that the constraints on secrecy must be defined and strictly curtailed to what is absolutely necessary. And language is in existence in our bill to support that amendment, as well as the need for notice obligations, which is an essential function for review mechanisms that would be necessary for this level of collection and sharing power, of course.
Now, even if the subject of this order did learn that this information was being, compelled by the telecommunications, and they said, they didn't think it was fair, they wanted to take the government to court over it, this legislation allows the government to conduct these court hearings in secret and not have to share their information with the subject of this. Is that correct? Can you kind of give us more explanation of how you see that working?
Yes, in the situation that an individual or institution would seek to challenge collection powers or orders under Bill C-26, there's a judicial review mechanism that's available. There's other complaint proceedings that are available at law outside of the scope of Bill C-26, but in this case, it contemplates secret evidence. And in this case, there is some language that is included, unlike the minister's discretion to keep secret the orders themselves, which doesn't appear to have any limits to that discretion. At least with respect to the secret evidence proceedings, there is some language in the bill. However, we've recommended that it be tightened and aligned with that which is set out in the Canada Evidence Act, as there's no justification for diluting that requirement, nor the court's ability to balance the public interest in disclosure in contrast to the government's interest in confidentiality. That's essential in our view with respect to the constitutionality of the scheme.
Thank you for that. And yeah, I think there could be very compelling and extraordinary circumstances where the government would have to keep certain information secret, certainly, but we don't want to allow legislation to go through that gives overly broad powers that could potentially be abused, however good the intentions of the people passing the bill might be. To the Privacy Commissioner, what sort of, in my last 30 seconds, what sort of personal information are you concerned could potentially be inappropriately shared under this legislation?
Well, similarly, I think subscriber account information, communication data, website visits, metadata, location data, financial. So it's that may not be what is ultimately requested, but we want to make sure that the bill doesn't allow for it. And so what we're recommending is that notion of necessity and proportionality would bring that rigor to say you may need it, but also consider if there are less privacy intrusive means to achieve the goal.
Thank you, Mr. Lloyd. Mr. Shefke, please, online. Thank you.
Thank you very much, Mr. Chair, and I too want to add my thanks to the witnesses for appearing today. I have some questions for Mr. Yalkin and then Ms. Robertson, and I'll begin with Mr. Yalkin. Mr. Yalkin, what new powers and responsibilities will be given to the Office of Superintendent of Financial Institutions under this Act?
Well, I think a lot would depend on the regulations, but as the committee will be well aware, there's a number of different expected outcomes associated with the legislation relating to identifying and managing and preventing and detecting and limiting damage associated with cyber attacks. A lot of those areas we're already quite active on, and we actually have a lot of levers through our supervisory work to be able to try to encourage financial institutions to respond to those different expectations. I think the difference here, if this legislation were to be introduced and regulations were to be introduced, rather than us relying on our supervisory oversight as a lever to try to encourage good practices, the case would be that there would be different expectations that would have the force of law, which would then be subject to regulatory enforcement. And in terms of like the specifics around those different levers, I suspect that there would be others who would be better placed to speak to them than I.
Thank you. You had spoken earlier about reports that were shared with you with regards to cyber attacks. Were those shared with you voluntarily, or was that mandatory?
So we have an incident reporting protocol where we set out for financial institutions our expectations of when and how they report incidents to us. Now, in a sense, one could say that they're voluntary, but I'll just give you a little bit of background if you'll permit me.
Please.
As a prudential, pardon me. As a prudential regulator, we have a general responsibility when it comes to overseeing financial institutions and making sure that they're engaging in sound risk management practices. And so what we do then is, instead of issuing regulations that have the force of law, we articulate for them our expectations of them, which we then supervise them against. So when we issue, for example, a reporting protocol, which we have in place, it's more often the case than it's not that financial institutions comply with it, because if they don't, we may consider that as part of our ongoing supervisory oversight of them.
Okay. This legislation includes mandatory reporting mechanisms. Do you agree with those? Why is mandatory reporting important?
So this legislation would be a little bit different in terms of what we currently have in place for reporting. So under our reporting protocol, banks report to us. So if something happens, we have a mechanism for them to indicate to us within 24 hours that an incident has occurred. Here, with this legislation, the reporting would be to the Cybersecurity Center. So there'd basically be dual reporting. We'd have to figure out, for example, how we effectively and efficiently facilitate that, because we have a form for reporting. Undoubtedly, there would be one under this particular regime as well, too. But that would be something we would be able to tackle with banks to make sure that the reporting expectations were clear to both coordinate parts of government.
Thank you, Mr. Yalkin. I'll turn my questioning over now to Ms. Robertson. Thanks for being with us today. I'm very interested in hearing more about some of the oversight mechanisms that you would like to see put in place. You had mentioned them earlier in the line of questioning. Can you expand on those? And perhaps comment a little bit on how Bill C-26 intersects with the Privacy Act. Is there anything in there that you see as problematic, and how can that be mitigated here in committee? What can we do?
There are a number of recommendations, including those identified in my comments on the last date, as well as in today's proceedings, and as well as those identified by Commissioner Dufresne. We have set out recommendations relating to the need for proportionality and reasonableness limits as an overarching framework that guides both the minister and the government in the implementation of the bill, but also the oversight mechanisms that should be attended attendant to the privacy interests and other interests that are at stake in this type of legislation. We have recommended that there be a formalization through the legislation of the role for independent regulators and the assessment of the proportionality criterion when considering potential orders to be put in place under the Act. And that we also have, in light of the really sweeping nature of the types of privacy interests that are engaged by the institutions at issue, including telecommunication providers, we've recommended for the constitutional, mindful of the constitutional obligations of the government in legislating, that judicial oversight be applicable to private information, de-identified information that has that reasonable expectation of privacy, which is absent from the legislation at this time.
Thank you, Chair, and thank you, Ms. Robertson. Mr. Yelkin.
Thank you, Ms. Robertson. We're going to move on to Ms. Michaud for 2.5 minutes, and then we're going to, Mr. Julian, you're going to be the last one up. 2.5 minutes and a hard stop. We're getting down on time here. Ms. Michaud, please.
Merci, Monsieur le Président.
Thank you, Chair. Welcome to the committee once again, Ms. Robertson. In the brief that you tabled to the committee, there are many recommendations. Thank you. That was very useful. You recommended the creation of a mechanism that will allow small telecommunications service providers with less than 250,000 or 500,000 subscribers could ask for temporary relief if they want to engage in new trade practices or organize their institutions or continue with any organization following a request by government. So can you tell us more about that? Because it's a question that I've asked many interveners that have come here. Will this be a problem to SMEs that have to comply with the law? Is there going to be more bureaucracy and additional workload for them? At the same time, it is disturbing to say that the government could force them to totally stop their trade practices. That may be part of the powers that the orders issued by the ministers concerned may have. So it makes me wonder at the extent to which those powers are broad and how can we control that? And that's the same question I asked Mr. Dufresne a while ago. Thank you.
Yes, and thank you for the question. My apologies for responding in English. Our recommendations here intersect with the public policy implications of the legislation, as well as potential constitutional risks around the equity impacts or potential discrimination impacts of the legislation and the order-making power. In terms of the need for standards for telecommunication providers to protect the security of individuals in Canada, that's absolutely necessary at a platform-neutral level. However, there are potential impacts for Canadians in regions, including rural or Indigenous communities who may suffer from the adverse impacts of smaller or mid-size providers being unable to maintain viability in implementing security measures. And we have noted that the CRTC has found recently that there have been successive years of declining competition in Canada, and particularly noted Quebec and Ontario is where their declines have been most significant. And so this is where we've identified the need for appropriate balances.
Thank you, Ms. Robertson. Ms. Michaud, Mr. Julian, please, for 2.5 minutes.
Merci, Monsieur le Président. J'aimerais revenir.
Thank you, Chair. I'll come back to Mr. Dufresne. The question I asked a while ago had to do with information that is shared outside the borders of a country. What I was trying to say is find out the country that has the best model for privacy protection, especially when we're dealing with information that is shared beyond the borders of that country. Do you have in mind any country that could serve as a model about that? There are several models. I will hesitate to name one as being the best. For example, the European model says these are our expectations when it comes to privacy protection, necessity and proportionality, transparency, something that's very important. And they require that other countries have an appropriate regime and they do an assessment. Canada has just received the status of adequate or appropriate country, and this compels that stringency. Others do so through agreements and treaties. Quebec in Canada, in its Bill 25, has the requirement to have an evaluation of privacy factors because data will be leaving Quebec. It's all about discipline and stringency and saying, let's think about privacy from the very beginning when we design an initiative and intend to implement an initiative. Thank you very much.
You mentioned earlier in 2022, 10 priority 1 incidences of cyber attacks. 2023, that moved to 30. How do you describe a priority 1 cyber attack? What is the difference between that level of cyber attack and others?
So, Mr. Chair, high priority ones are basically high impact incidents that cause disruption of service or leakage of data. So any that would sort of meet that definition would constitute priority 1 and be accordingly reported to us.
So we're basically seeing an incident of that magnitude every 2 weeks or less. At this point, are you concerned about that number growing? And as some witnesses have indicated, if we don't put in place protections, for example, with C26, that increasingly Canadian financial institutions may be targets?
We are concerned with that number growing. We're tracking it very carefully, and we are eagerly watching to see whether or not the trajectory continues to grow. This is an area of risk for financial institutions. We've outlined it in our annual risk outlook, published it on our website. And cyber risk for really us is, and cyber attacks, which constitute an element of that.
Thank you, Mr. If there's information that you feel that Mr. Julian would like to have as part of his question, please forward it to him. I want to thank all the guests for today. We appreciate your time. It's a valuable time, but it's a very important topic. So we're going to take a suspension for about 5 minutes till we get set up for the next guest. Thank you. like to welcome our second panel of witnesses. In person, Canadian Telecommunications Association, Eric Smith, Senior Vice President, Robert Giz, President and Chief Executive Officer. By video conference, Canadian Bankers Association, Angelina Mason, General Counsel and Senior Vice President, Legal and Risk. Charles Docherty, Assistant General Counsel and Vice President, Legal and Risk. As an individual, Andrew Clement, Professor Emeritus, Faculty of Information, University of Toronto. Up to 5 minutes will be given for opening remarks, after which we will proceed with rounds of questions. We will start with you, Mr. Giz, please.
Thank you, Mr. Chair, and good evening. As was said, my name is Robert Giz. I'm the President and CEO of the Canadian Telecommunications Association, and I'm joined today by our Senior Vice President, Eric Smith. L'Association Canadienne des
The Canadian Telecommunications Association is dedicated to building a better future for Canadians through connectivity. Our members include service providers, manufacturers, and other organizations that invest in world-class telecommunications networks in Canada. We are happy to be able to take the floor here today to present the opinion of our association on Bill C-26.
of Canada's telecommunications system is of the utmost importance. Our members recognize that their services are critical to the social and economic well-being, as well as the security and safety of Canadians. Accordingly, our members invest significant resources to safeguard their systems and infrastructure from cyber attacks and other threats. Members also actively participate in the Canadian Security Telecommunications Advisory Committee, or CSTAC, which facilitates the exchange of information between the private and public sectors, as well as strategic collaboration on current and evolving issues that may affect telecommunications systems, including cybersecurity threats. In addition to providing connectivity services, many of our telecommunications service providers also deliver cybersecurity solutions to businesses across the country, helping them protect their operations against cyber attacks. In other words, our industry takes security seriously and is committed to the security of the Canadian telecommunications system. As such, we share the Government of Canada's objective of protecting critical infrastructure from cyber attacks and other threats. However, Bill C-26 in its current form raises some concerns. We have outlined our concerns and proposed amendments to the legislation in a written submission to the Standing Committee. I will just mention a few of them, all of which pertain to Part 1 of Bill C-26, the proposed amendments to the Telecommunications Act. First, the bill gives the minister very broad order-making powers that lack appropriate checks and balances. Given their extremely broad scope and potential impact, the proposed legislation should be amended to impose conditions on the exercise of these powers. Specifically, orders should not only be necessary in the opinion of the minister, they should be reasonably necessary. In other words, proportionate to the potential harm of the security risks and reasonable in the circumstances. The legislation should also require orders be made only after the minister has consulted with prescribed experts to ensure that orders are proportionate to the risk posed, have a limited impact on service availability, and are economically and operational feasible for affected service providers. Second, while orders made under the bill are subject to judicial review, the legislation provides that the judge can base his or her decision on evidence that the applicant is not allowed to see, therefore cannot challenge. This process makes no effort to provide for alternate means of testing the government's evidence, including the appointment of a special advocate with the appropriate level of security clearance. Third, Bill C-26 does not include a due diligence defense for alleged violations of orders made pursuant to the proposed new sections of the Telecommunications Act, even though a defense of due diligence is available for other violations of the Act, as well as for violations of orders by others under the rest of Bill C-26. The absence of a due diligence defense is even more striking, given that the legislation seeks to introduce significant monetary penalties. Telecommunication service providers should have the right afforded to others under Bill C-26 to avail themselves of a due diligence defense in appropriate circumstances by demonstrating that they took all reasonable care in the circumstances to avoid the alleged violation. Lastly, Part 1 of Bill C-26 should be amended to make clear that compensation may, at the discretion of the government, be awarded for any financial expenditures, losses, and costs resulting from complying with an order. Nous vous remercions de nous avoir donné l'occasion.
We thank you for this opportunity to express our point of view on this very important issue. We will be happy to answer your questions now.
I now invite Ms. Mason for her opening statement, please.
Thank you. Good evening. I would like to thank the committee for inviting us here today to provide our views on Part 2 of Bill C-26, an act to enact the Critical Cybersecurity Systems Protection Act. My name is Angelina Mason, and I am General Counsel and SVP of Legal and Risk at the Canadian Bankers Association. I am joined by my colleague, Charles Doherty, Assistant General Counsel and Vice President, Legal and Risk. The CBA is the voice of more than 60 domestic and foreign banks that help drive Canada's economic growth and prosperity. The CBA advocates for public policies that contribute to a sound, thriving banking system to ensure Canadians can succeed in their financial goals. Banks in Canada are leaders in cybersecurity and have invested heavily to protect the financial system and the personal information of their customers from cyber threats. We are also a highly regulated industry and comply with robust requirements from the Office of the Superintendent of Financial Institutions in respect of cybersecurity risk, supply chain and third-party risk management, and incident reporting. The security of Canada's critical infrastructure sectors is essential to protect the safety and security and economic well-being of Canadians. The banking industry counts on critical infrastructure sectors such as telecommunications and energy to deliver financial services for Canadians. We have encouraged the government to leverage and promote common industry cybersecurity standards that would apply to those within the critical infrastructure sectors, and we support the government's efforts to achieve this under the Act. We recognize that critical infrastructures, such as energy, cross jurisdictional boundaries, and we have also recommended that the federal government work with provinces and territories to define a cybersecurity framework across all critical infrastructure sectors. Having consistent, well-defined cybersecurity standards will provide for greater oversight and assurance that these systems are effective and protected. Protecting against state-sponsored and other threat actors requires a coordinated approach between the government and the private sector. The government can play a pivotal role, bringing together critical infrastructure partners and other stakeholders and building upon existing efforts to respond to cyber threats. While recognizing the importance of the Act, we need to get this right. Some of the proposed provisions need to be better tailored to address operational and other risk concerns, including being able to leverage existing robust requirements of specific sectors like banks to mitigate against duplicative or inconsistent requirements, providing greater safeguards for the protection of confidential information, and improving the threshold and timing for cybersecurity incident reporting. In addition, there should be appropriate guardrails for the invocation of the government's very broad powers under the Act. Consistent with other legislation, the Act should also include safe harbor provisions that provide designated operators immunity from civil and criminal proceedings for good faith compliance with the Act's reporting requirements and cybersecurity directives. Looking beyond mandatory incident reporting, the Act should also support broader voluntary sharing of incidents, cyber threat information, and expertise about cyber protection with the community security establishment and among classes of designated operators, while also including safe harbor provisions to enable this sharing without creating additional risk. Effective sharing of this type of information is a critical component to cyber resiliency and should be fostered through the Act. Finally, we believe it's necessary to allow the establishment and CSIS to share relevant intelligence and information with designated operators of critical cybersecurity infrastructures in Canada to help them effectively prevent and mitigate cybersecurity incidents. We will be following up to provide the committee with additional written details on these recommendations. We want to work collaboratively with the government and with other sectors to ensure that Canada remains a safe, strong, and secure country. We look forward to your questions.
Thank you, Ms. Mason. Now we'll move on to Professor Clement, please, for your opening remarks.
Thank you, Mr. Chair, committee members. I'm Andrew Clement, a computer scientist and professor emeritus in the Faculty of Information at the University of Toronto. I co-founded the Interdisciplinary Identity, Privacy, and Security Institute there. For the past decade, I focused on the privacy, security, and surveillance aspects of Internet communications. Currently, I co-lead a project with the Canadian Internet Registration Authority on Internet measurement aimed at advancing Canadian cybersecurity resiliency and sovereignty. The project is funded through Public Safety Canada's Cybersecurity Cooperation Program. Beyond an annual $1,500 honorarium, I've received no funds from either CIRA or Public Safety. While I endorse CIRA's submission to your committee, I am speaking here in a personal capacity. I strongly endorse the recommendations in the submission by the Citizen Lab and the joint submission by several civil society organizations. Both of these submissions draw heavily on the fine report by Dr. Chris Parsons, Cybersecurity Will Not Thrive in Darkness. There's no debate over whether Canada needs a stronger regime for securing our critical cyber infrastructure. C26 contributes to establishing a worthy cybersecurity regime. However, it needs substantial amendment to ensure that the sweeping and secretive powers it grants the government do not override other equally vital values, such as privacy, freedom of expression, judicial transparency, and government accountability. For better and worse, the government's leading agency for ensuring cybersecurity is the Communications Security Establishment. It faces a vital and remarkably difficult task. Fortunately, it appears to be staffed by dedicated experts. However, unsurprisingly, given its origins in wartime signals intelligence, CSA operates with an extraordinary degree of secrecy and boundless appetite for data collection. This is quite justified in some areas of its mandate, but as its capabilities have grown to include extensive surveillance of domestic communications, CSE needs to be much more open and publicly accountable. In 2013, Snowden documents, notably about CSE's Cascade Joint Cyber Sensor Architecture, indicated that the agency was embedding extensive interception capabilities within the internet infrastructure, able to capture a very large portion of Canadians' internet communication. While CSE is legally prohibited from directing its activities at Canadians, its capabilities of full take of content and metadata, mass surveillance, and the incidental bulk collection of personal, even intimate information on every Canadian internet user poses a significant challenge to privacy rights and democratic governance more generally. As renowned cybersecurity expert and director of the Citizen Lab, Ron Diebert, noted in 2015, these are awesome surveillance powers that should only be granted to the government with enormous trepidation and only with a correspondingly massive investment in equally powerful systems of oversight, review, and public accountability. Basic questions here are whether the government should make Canadians aware of this mass surveillance, provide them with robust assurances that this bulk collection is necessary, proportionate, and safe, and offer them an opportunity to decide collectively whether such practices are acceptable or not. As mentioned by previous witnesses, a key concern with C26 is its failure to restrict the CSE's use of information it collects under its extensive new C26 powers. As Kate Robinson has made clear earlier, based on NCIRA reporting, if not explicitly prohibited from doing so, the CSE will consider itself authorized to use this information across any of its mandates. This accountability deficit must be fixed before granting CSE new powers under C26. Privacy is a fundamental human right. It is essential that C26 be amended to explicitly define personal and de-identified information as confidential and to ensure the government obtains a court order before requiring its disclosure. The government must not be allowed to use its sweeping new powers to undermine privacy, such as by weakening encryption or communication security. and data retention periods must be attached to the information it collects. Before closing, I'd like to briefly raise an issue missing from C26, but which your committee has previously considered important: how the government should handle cybersecurity vulnerabilities. Where C26 requires telecommunications service providers to conduct assessments to identify any vulnerability in their services.
Mr. Clement?
Yes?
Yes. Perhaps you could wait and maybe we'll get that feedback through questions. We're over our time. So I'm going to move on now to Mr. Motz, please, for 6 minutes.
Thank you very much, Chair, and thank you to the witnesses that are here, both in person and online. This question, the first one is to all three different groups. Now, since I've been here in 2016, I've seen this government constantly attempt to use legislation to give themselves excessive power and avoid accountability. Now, I think back to C-59, their so-called National Security Act in 2018, their attempts during COVID to have over 2 years of unquestioned authority to spend taxpayers' money without accountability. There are attempts to control what Canadians see and say on the internet through C-11 and C-18, and of course, their unprecedented use of the Emergencies Act in 2022, which the federal courts just recently, as you know, ruled illegal and unconstitutional. Now, the pattern with this government and their legislation should concern Canadians. And given each of your organizations that you represent and Professor Clement in your research, does this bill, as it currently reads, not give you pause, especially when it comes to legislating powers that limits Canadians' fundamental rights and privacy? And I guess, Ms. Mason, I'll start with you first. Nice to see you again from the Emergencies Act Committee. This time, we're hopeful to be preemptive as opposed to try and fix it after the fact, as we tried to do the first time. So if you could answer that. And then in your responses for all three, further to what you may have already suggested, how should the committee address the concerns that Canadians have and that you have with those shortcomings?
Yes, as mentioned in our opening remarks, they do need appropriate guardrails. You have to introduce notions of proportionality. Right now, the powers with respect to cybersecurity orders, directives are so broad, we're not even quite certain just how far those directives could go. So we definitely think the legislation needs to build in appropriate guardrails so that all participants can feel comfortable that the government's acting within a reasonable space. Okay,
Mr. Clement?
Yes, in addition to proportionality, which has been mentioned several times, much greater transparency about the operations of the security agencies and the measures that are being taken is required. At this point, we do not have that kind of transparency, and there are many recommendations, particularly made in the reports that I mentioned earlier, that address greater transparency, so Canadians can know what's going on, and that would achieve a much better balance. At this point, the Bill C-26 is not balanced in terms of those abilities.
Okay, Mr. Giz or Smith?
Thank you. So I think, as I said in my opening statement, we all agree that the premise of this bill is important. It's something that we do need. But when it comes to transparency, accountability, judicial rights, there are some areas that need to be tidied up, and I think those are the main areas. We've in our submission that we sent in, we put in specific amendments in there, and I think that that's part of democracy and parliamentary democracy. Is this committee will have the opportunity to introduce amendments and hopefully send it back to the House in a better manner than when it arrived.
All three of you for that response. Now, we've heard repeatedly terms of overly broad, terms of proportionate and reasonableness. And Ms. Robertson from the Citizen Lab in the previous panel said that we need to make the right decision now, and that's critical. So, and I agree with her recommendation for appropriate judicial oversight. Now, having said that, how would each of the three groups suggest that we achieve that appropriate balance of judicial oversight, to protect privacy rights, and you balance that against the need to act to protect critical infrastructure and act expeditiously in some circumstances on what they would call in the banking industry a priority one critical infrastructure breach, and to protect that infrastructure plus the public and their information in those situations where it's warranted. How do we go about doing that to strike that right balance? And I'll start off with Mr. Smith and then go to Mr. Clement and Ms. Mason.
Yeah, thanks for the question. I think, we're certainly not suggesting that there be judicial oversight over every aspect of the decision-making process in terms of before the decision's been made. Certainly there needs to be judicial oversight, rights of appeal, rights for the targets of an order to be able to question the order, to challenge whether it's proportional, whether it is appropriate. When the commissioner, privacy commissioner was here, he talked about consultation in terms of making sure that privacy rights are respected. So I think that depending on what aspect of the bill we're looking at, the role of the judiciary will vary. But I think it's all part of what I think most witnesses are saying is that there needs to be checks and balances.
Thank you. Mr. Clement?
Yes, one of the things I think that could be improved, and it's raised by Kate Robinson, is the role that NSERA, the National Security Intelligence Review Agency, can play. It's very concerning that it is reported repeatedly that it has not been able to establish that CSE has been operating legally because it hasn't had access to the information that it needs to make that assessment. I think that's very concerning, and something in the bill, recommendations that provide that transparency and that enable CSERA to get access to that information would be valuable.
Ms. Mason, quickly, we're just about done.
Sure. It's providing thresholds of when orders would even be considered. We're quite concerned because if you are an operator and you're dealing with your situation, you're doing your darndest to make sure you're bringing it under control and doing the right things. So it's at what point does the government then step in? Are they privy to knowledge that you don't have? What are they asking you to do? Is it reasonable? So to me, there should be thresholds, particularly when the operator themselves is doing their work in trying to manage the situation.
Please.
Thank you, Mr. Chair. I'm going to start with the Canadian Telecommunications Association. So we've certainly heard a lot about the order-making powers of the minister and the concern about their confidentiality. And I think these are legitimate concerns. So I'm wondering, first of all, if you can give us any insight, if you have any idea what sort of orders these might be. Can you anticipate the sorts of orders that might come from, or is that too speculative?
Yeah, you have to be careful about being speculative, but I think that we've already seen that the government has made a policy statement in 2022 regarding requirement to remove equipment from specific suppliers from the infrastructure of telecommunications providers. So that's an example. But the order-making powers are very broad, as you know. It's to do or refrain from doing anything. So it could be cutting off service to a particular organization, individual, what have you. It could be requiring you not necessarily to take out equipment from your infrastructure, it could require you to put certain equipment into your infrastructure or to comply with certain standards. So it could be weakening of encryption. It could be requiring you to intercept communications. So it could be really, the way it's currently drafted, it could be very broadly interpreted.
One of the concerns I understand is to make such orders public, it would expose potentially vulnerabilities to various industry practices to bad actors. Do you have any comments on that?
Yeah. Again, in terms of, are you talking about the confidentiality of the order or confidentiality of information supplied?
If the order was made public, it might expose vulnerabilities to bad actors. Right?
Yeah. No, that's a good question. And we're definitely sensitive to that. There's definitely circumstances where portions of an order, or in some cases all the order, there may be legitimate reasons why it needs to be kept secret. But I think the way we look at it is that secrecy should be the exception rather than the norm. And that's where I think it's appropriate to have, any judgment to keep an order or requirement to keep an order confidential should be tested, to go to a judge for the government to show the evidence that this is why this should be kept confidential, so that there's the opportunity to test that assumption.
So you mentioned in this context the notion of a special advisor or advocate, if you will. Can you outline what you see as the role, the kind of the powers of such a role, and perhaps whether or not there's any body within the government presently who could step into that role as part of their work?
Yeah, there's already existing mechanisms where, in situations, court hearings where there is confidential or secret information that can't be made public or shared with the target, where a special advocate who has the required security clearances can question the government, can test the evidence, test the assumptions that were made. So it's not a perfect situation, but it is at least provides some mechanism by which the government's evidence can be tested.
And you mentioned the need for checks and balances. You mentioned the need for the reasonability of these orders and rationalization of these orders. Can you suggest any further checks and balances that would be required here?
Certainly. I think that we've put in our recommendations that, right now the way it's worded is if the minister believes it's necessary to do or not do something. I think that it's important to be required that the order be made only after consulting prescribed expert bodies. So that could be CSTAC, for example. It could be other cybersecurity bodies within the government. Not only to determine whether there's a security threat, but whether the order is proportionate and balanced. Because let's face it, our communications systems are very complex, and it may seem easy to say, oh, remove this equipment or do something, but we want to make sure experts, including the targets of the orders, if appropriate, can advise the government of what maybe some unintended consequences could be to the system, to the viability even of some of the smaller providers who are asked to comply with those orders. So I think that that's a very important requirement that should be in the legislation.
So as a consequence of some of these orders, different providers may be required to add or remove equipment or change their software, and that entails costs. So as part of your submission that they should be indemnified from such costs?
We're not saying they should be indemnified. What the legislation right now, and it could be just a drafting issue, says that providers are not entitled to compensation, and that's open to interpretation. Does that just mean they don't have a right at law of compensation, or does that mean the government, they cannot be compensated? What we're just suggesting is there should be discretion for the minister or government council to award compensation based on case-by-case basis, and that providers who are impacted by those orders should be able to make representations as to whether they should or why they should receive compensation. For example, in the United States, the government set up a multi-billion-dollar fund to help certain class of providers remove Chinese supplied equipment from their infrastructure.
Last question, the due diligence defense. Can you give us more information about that?
Sure. It's kind of a puzzling thing for us in the legislation because all other affected parties in the legislation are able to show if they're alleged to have committed a violation. A defense could be that they've done everything reasonably possible to avoid making that violation. It could be, for example, if the government says you must replace this equipment in your infrastructure with equipment somewhere else, and it's not even available in the market. For whatever reason, the legislation says we're the only parties that are not entitled to make that defense.
Thank you, Mr. Smith. Mr. McKinnon, we're going to move on now to Ms. Michaud, please.
Merci, Monsieur le Président.
Thank you, Chair. Thank you, witnesses, for your presence here. My first question goes to the representative of the Canadian Telecommunications Association, and I'll be asking the same question later on to the representative of the Association of Canadian Bankers. We almost all agree that C26 is one step in the right direction. It's relatively good news that the government is working on this matter of cybersecurity, but there are some widespread fears when it comes to information protection, privacy protection, the overly broad powers of government through order and so on. So I'm asking you, you represent telecommunications providers and organizations that invest in telecommunications network like Videotron, Rogers, Bell. These are all large organizations which I imagine are already investing to protect themselves from cyber attacks. And they have the means to do that. Maybe you could also represent smaller organizations with less subscribers, less customers. This may be extra work for them. We may think that some of them have already had cyber attacks. So I'm wondering, right now, these organizations that you represent, how are they preventing such things? What will be Bill C-26 change for them? Bear in mind what I said at the beginning. Does this bill seem to be a burden or a relief for these organizations? If C-26 is not amended to add the powers that the government is giving itself? I know it's a very vast question that I've asked.
It's a very good question, though. I think one of the things is our members have very robust cybersecurity processes already, and as Mr. Giz mentioned in his remarks, already collaborate deeply with government, and so many of the things that could come about as a result of C-26 are things the industry is already doing. The CSTAC organization, the Canadian Security Communications Advisory Committee, it puts out best practices and guidances, et cetera, for all the telecommunications service providers. Bill C-26 could require. I was doing my ventriloquism routine there. It could allow the minister to actually order specific practices, for example, employed. In terms of the regulatory burden, I don't know of any industry that welcomes additional regulations. It does add some burden. But again, our members already have robust practices, so I think the additional burden is probably mostly around the things like the reporting requirement. And that's where, again, legislation could require some improvements. It says, must immediately report an incident. Well, immediate is right away, and you really wouldn't have enough information to even know if you had an incident. Some of those things can be improved. I hope that's answered your question.
Oui, absolument. Merci beaucoup.
Yes, indeed. Thank you. I will put the same question to the representatives of the Canadian Bankers Association. According to the Office of the Office of the Superintendent of Financial Institutions, banks are also targets of cyber attacks. This could be a source of fear for clients when it comes to the protection of their personal information. Just as is the case for telecommunications organizations, I imagine that some banks already have some mechanisms in place, and as Mr. Smith is saying, they're already doing what C-26 is asking for. What does this represent more? Is it a relief or a burden? What should be further controlled, in your opinion?
Well, for us, if you look at the Office of the Superintendent, and I will confirm the view given by that office that we do treat that reporting as mandatory, that the importance of that reporting, and I want to clarify a couple of things. One is the reporting that goes to OSFI is for technology and cyber. So if there's a technology incident, even if it's not cyber related, or if you think of some sort of infiltration into your system, that is reported, because what OSFI is very concerned about is the resiliency of our systems and being able to not just secure but also deliver our services. So if you look at that type of reporting, it's intended to help identify areas of potential concerns so then that can then be shared back and people can have stronger systems. So that's now being done within silos. So we do that with OSFI. The whole point of this legislation was to identify the critical sectors and say the major players in these sectors, because what they represent to the security of our whole ecosystem, they should be reporting into one central location. So you're not only hearing what's happening here, you're hearing what's happening in that sector, so that we can identify if there's a shared concern, if there's learnings there, if somehow what's going on is connected. So a key part of this legislation was really to improve the available information to help combat against cyber threats. So that's definitely a positive that we see, and that's why we've encouraged it to actually even go broader to allow voluntary sharing at all levels within the ecosystem. So that's very positive. And also the fact that, you know, we do our cybersecurity planning, other sectors do their cybersecurity planning, and now that will be validated and centralized. So we can look again for learnings, should there be different things in different jurisdictions.
Thank you, Ms. Mason. Mr. Julian, please.
Thanks, Mr. Chair. Thanks to our witnesses. I'll start with you, Mr. Giz. The Canadian Telecommunications Association has had how many cyber attacks in the past year? And I'd like to know whether you're finding the trend increasing, is it staying stable, or is it decreasing?
So unlike the financial individual who was on earlier, we're not a regulator, so we're not privy to the private information of our members. So unfortunately, I don't have that information.
But anecdotally, there would be some discussion within the association, wouldn't there?
And in terms of private, personal business within, no, we're not privy to the information.
Can I ask you then, if you're sharing best practices, surely the types of cyber attacks may be similar across your sector, right? Is there information sharing that helps other companies, for example, put in place protections against cyber attacks?
So they do that with themselves, with government through CSAT.
Yeah.
It's not through our association that would happen.
Okay. I will ask you to what extent you were consulted around the drafting of C-26.
Okay. So as an association, we were not consulted. We worked with our members to find best practices, and there's a chance they may have been consulted, but we were not advised on that either. But as an association, we were not consulted. We participated in the submission to the committee.
Okay, thank you very much. Ms. Mason, same question to you. To what extent was the Canadian Bankers Association actually consulted on the drafting of C-26?
We did not participate pre-drafting. We have advocated for some time now for common industry standards. We were able to share our thoughts once the first draft was out by meeting with public safety and highlighting a number of the recommendations we've presented here today at committee.
Okay, and OSFI, you may have heard their testimony just earlier tonight, talked about a move in 2022. There were 10 Priority 1 cyber attacks. In 2023, that tripled to 30 Priority 1 cyber attacks. Is this your experience as well within the Canadian Bankers Association, that the number of cyber attacks members of your association is increasing? Do you share, very similar to the same question I asked Mr. Giz, to what extent do you share best practices? To what extent is there communication amongst the members to make sure that you are able to head off what often may be similar types of cyber attacks against your members?
So definitely share best practices. I don't believe we would get into the specifics of a particular number of reporting. In the case of OSFI, they cover all federally regulated financial institutions, so I'm not privy to which one of those would have been our members. But I think the point is that, you know, they are being reported with the view to making sure that they can be shared within the network and addressed appropriately.
Thank you. I'd like to move on to Professor Clement. You signed on along with a number of important organizations, the Canadian Civil Liberties Association, Ligue des droits et libertés, National Council of Canadian Muslims, Open Media, Privacy and Access Council of Canada, pushing for a series of amendments, 16 recommendations that help to, in the words of the briefing, restrain ministerial powers, protect confidential personal and business information, maximize transparency, allow special advocates to protect the public interest, and enhance accountability for the communication security establishment. These are very valuable recommendations that you brought forward to us, or the coalition has brought forward to us. What are the most important ones, the ones that we need to be absolutely cognizant of in putting forward amendments to C-26?
Well, there are many recommendations there, and thank you for that question. Well, we've just talked about a number of them, but I would say the first recommendation about the identifying, sort of constraining the scope of the ministerial orders, which at this point is relatively unbounded, except by a general sense of necessity, would be one of them. There are a number that require or call for amendment for transparency measures, reporting, and so on. Those sort of cumulatively are very important. As I was saying earlier, that they need to create a much better balance between the sort of the security interests on one hand and the other rights, and so I'll leave it there. But and I can follow up with a more specific priority if you'd like.
Thank you for that. But what you're saying is there are some major difficulties with C-26 that need to be responded to, that the bill itself needs to be considerably approved. There are a number of amendments that need to be considered for the bill to do what it purports to do, but also ensure that the protection of information and the transparency is there. Is that not true?
Yes, absolutely.
Julian, Mr. Clement, your time is up, please. We're moving to the next round. And
Chair,
yes.
I'm sorry, but it's 6 o'clock. I have to go, and I do not consent to continue the meeting.
It's 5:50, right? That clock's fast. It's 5:51. That's correct. So, Mr. Julian, let me let me proceed. It's I'm going to say 2.5 minutes. And Mr. Julian, you have the last question. So if you want to forego those 2.5 minutes, that's great. We'll get out of here a little quicker. But we have 2.5 minutes.
Mr. Chair?
Mr. Couric, you're up, please.
Thanks very much, and I appreciate the opportunity to engage in this important subject matter. Professor Clement, I believe the term you used was awesome power, if I'm recalling correctly. You know, certainly the surveillance capacity potential, if there are not appropriate safeguards in place, is certainly awesome, or I would maybe suggest another a word to use would be terrifying. Are you confident that as the bill stands right now that there are safeguards in place that would protect Canadians' privacy, their data, and their rights?
I'm not confident as it stands now that those rights are protected. It's a very one-sided bill, and in that regard, it gives too much discretion and power to government agencies without the necessary transparency and accountability.
Thank you very much. I appreciate that, and to our to our witnesses in telecom and the banks, about two industries that are about as popular as politicians are. This has been described as a one-way street in terms of reporting. The mechanisms required to release data to government, some uncertainty as to where data would go, whether it's proprietary information and whatnot. So I'm wondering, I want, in about the minute I have left, so about 20 seconds each, if you could, just describe some of the concerns that you have that the reporting mechanisms are right now a one-way street, and if you feel that that needs to be addressed. I'll start with you folks in the room.
Thanks. Well, obviously, I've got the double whammy on that in politics and telecom. So, you know, when it comes to that, I agree with a lot of what has been said already, and that is this bill is good intentioned, but it needs to be improved, and it gets improved with openness and transparency and making sure that the right checks and balances are in place.
Thank you very much. And to our last witness, if you have about 20 seconds, if you could.
So I'm happy to jump in. I think there's a strong focus on intervention, and there should be a stronger focus on sharing information to the benefits of the participants in the system.
Thank you, Mr. Kurek. Ms. Michaud, please. 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Chair. I will take advantage of my turn.
Thank you. I've been too quiet.
I will get to you. Yeah, forgot she was here.
Thank you, Mr. Chair. Thank you to the witnesses. Madame Michaud actually asked similar question that I wanted to ask, and Ms. Mason, you pretty much touched on it, and I suspect banking will be already kind of ahead of the game in terms of what this legislation is doing. So I'm going to focus my question to our telecom witnesses here. The issue and the question around privacy and privacy protection is very real and something we're definitely wanting to make sure that balance is right. But on the other side, one could argue that if you are not dealing with critical infrastructure, such as telecommunication infrastructure, in the right way, those bad actors who could access that are not caring about the privacy protection of Canadians. Through telecoms and banking, which again I think Ms. Mason touched on, you hold a lot of data for Canadians, including location data, credit card data, a lot of personal information, and that if your systems are not protected with the constant moving ebb and flow of cybersecurity, because let's remember, it is constantly changing. So if you're not able to react to those changes and work with government, don't you think the risk to Canadian privacy is far greater, being exposed to bad actors who want to access that data and sell it or produce it for nefarious reasons? Wouldn't the privacy of Canadians be better suited with strong cybersecurity infrastructure?
Well, yes, and I think that our industry is doing a very good job in that. It's a critical function of what our members do, and they do a very good job of it. As you mentioned, bad actors are constantly evolving their techniques, and we're having to always modify our processes and our technology, but I think the industry does a very good job of it.
Thanks, but you asked questions too about physical changes within what some of your membership might be able to access or not. And I would again argue that if there are concerning trends that maybe not even in Canada but worldwide, and there is an opportunity to secure our infrastructure, critical infrastructure, that working with government would, again, it's not just the operations of the telecoms. You hold a large responsibility, which government has been helpful with, that you owe it to Canadians that if we are concerned about trends, that you implement those changes to protect Canadians' data.
Thank you, Ms. O'Connell. Ms. Michaud.
Prise 2. Merci, Monsieur le Président.
Take 2. Thank you, Chair. I have a simple question, and it's a question I've put to other witnesses during other meetings. C26 provides for heavy pecuniary sanctions if an organization doesn't comply with any request made by government, and we don't know what those requests will be because the powers are overly broad. So I will ask the interveners here, is it an exaggeration to impose those sanctions? And some said maybe there should be incentives applied instead to encourage organizations to comply to government requests. Others said instead of sanctions, we should opt for incentives. Others said we maintain the sanctions but introduce incentives. So the question goes for Mr. Smith or Mr. Gaze. What do you think of those financial sanctions for organizations that do not comply?
Thanks for the question. I mean, incentives are always good, especially, there's some organizations, smaller organizations, that it may be a greater burden in order to introduce new measures. But I think we have a lot of incentive already. Our reputation, our members' reputations are built on protecting privacy, protecting security, etc. Our concern with the penalties are, one, they are very large and they are cumulative, but also, as I mentioned before, is for some reason we're the only industry that's not afforded a due diligence defense, which, to be clear, just means that an organization could have done everything as reasonably possible to comply, but there could be something in order for whatever reason outside their control that they were not able to do, and yet they're subject to huge monetary penalties and even criminal sanctions against individuals.
Merci. Peut-être.
Thank you. Maybe if I have some time left, the other interveners could answer.
Sure, I'm happy to jump in. We're a highly motivated, highly compliant industry, so incentives aren't really necessary in that regard. I do agree that where incentives can come into play is for small to medium-sized businesses to help them achieve compliance, but not for the large designated operators and players contemplated by this legislation.
Thank you, and thank you, Ms. Michaud. We're right on schedule. I appreciate the witnesses today. Before we ask for adjournment, I just want to make people aware that C26, our last meeting, is Thursday, and we're contemplating possibly having the amendments in ready for clause by clause when we come back. So it'll be by Wednesday noon next week. But I know there is some discretion, so we'll have further likely discussions on that on Thursday. But that was kind of the outline. Yeah. Well,
week after.
Yeah. Okay. So, motion to adjourn. Adjourn. Thank you.
Thank you.